Get ready for the dictation. Start. Before this court, the Union of India contended that the employees in question belonged to the category of casual laborers and had not been regularly employed. As such, it was urged that they were not entitled to the same privileges which were extended to regular employees. This court, while adjudicating upon the controversy, took into consideration the fact that the employees in question were rendering the same kind of service which was being rendered by regular employees. The submission advanced before this court on behalf of the casual laborers was under Article 38(2) of the Constitution, which provides that the state shall, in particular, strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities, and opportunities not only amongst individuals but also amongst groups of people residing in different areas or engaged in different vocations. It was also urged on behalf of the employees that the state could not deny the minimum pay in the pay scales of regularly employed workmen, even though the government may not be compelled to extend all the benefits enjoyed by regularly recruited employees. While adjudicating upon the controversy, this court expressed the view that the denial of wages claimed by the workers in question amounted to exploitation of labor. It was held that the government cannot take advantage of its dominant position and compel any worker to work even as a casual laborer on starvation wages. It was pointed out that a casual laborer who had agreed to work on such low wages had done so because he had no other choice. In the opinion of this court, it was poverty that had driven the workers to accept such low wages. In the above view of the matter, in the facts and circumstances of the case, this court held that classification of employees into regularly recruited employees and casual employees for the purpose of paying less than the minimum wage payable to employees in the corresponding regular cadres, particularly in the lowest rung in the department where the pay scales were the least, was not tenable. This court also held that the classification of laborers into three categories depicted in the orders dated 15/5/1980 and 26/7/1984 extracted above for the purpose of payment of wages at different rates was not tenable. It was held that such a classification was violative of Articles 14 and 16 of the Constitution, besides being opposed to the spirit of Article 7 of the International Covenant of Economic, Social and Cultural Rights 1966, which exhorts all state parties to ensure fair wages and equal wages for equal work. Accordingly, this court directed the Union of India and the other respondents to pay wages to the workmen who were engaged as casual laborers belonging to different categories at rates equivalent to the minimum pay in the pay scales of regularly employed workers in the corresponding cadres, but without any increments. The workers were also held to be entitled to corresponding dearness allowance and additional dearness allowance, if any, payable thereon. It was also directed that whatever other benefits were being extended to casual laborers hitherto before would be continued. Harbans Lal versus State of Himachal Pradesh, decided by a two-judge bench. The petitioners in this case were carpenters employed at the wood working center of the Himachal Pradesh State Handicraft Corporation. They were termed as daily rated employees. Their claim in their petition was for emoluments in terms of wages paid to their counterparts in regular government service under the principle of equal pay for equal work. On the factual matrix based on the averments made in the pleadings, this court felt that the corporation with which the petitioners were employed had no regularly employed carpenter. It is therefore evident that the claim of the petitioners was only with reference to carpenters engaged in different government services. In the instant factual backdrop, this court expressed the view that the claim made by the petitioners could not be accepted because the discrimination complained of must be within the same establishment owned by the same management. It was emphasized that a comparison under the principle of equal pay for equal work could not be made with counterparts in other establishments having a different management, or even with establishments in different geographical locations though owned by the same master. It was held that unless it was shown that there was discrimination amongst the same set of employees under the same master in the same establishment, the principle of equal pay for equal work would not be applicable. It is therefore that the claim of the petitioners was rejected. Stop.